Okay, today is Thursday, May 24th. This is Amnesty International in Philadelphia, and we have as our guest speaker Professor Roger Clark. And he is the Board of Governors Professor of Law at Rutgers Law School in Camden, where he teaches international criminal law and other international law subjects. He is a graduate of Victoria University of Wellington in New Zealand and Columbia Law School in New York. In 1965, he was one of the founders of the first Amnesty International group in New Zealand and of the New Zealand National Section. He represented the government of Samoa in the negotiations to create the International Criminal Court and in subsequent negotiations on activating the court's nascent jurisdiction over the crime of aggression. So here we have, over to you, Roger.
Thanks a lot. This is the 20th anniversary of the adoption of the Rome Statute of the International Criminal Court on the 17th of July 1998. There are a lot of formal and very stuffy conferences going on around this subject, all of which I've managed to avoid, which is why I'm kind of pleased to talk to you in a more informal way about some of these matters involved in the creation of the International Court. Let me just say a word about my own involvement in this matter. I began a law teaching career in New Zealand back in the 1960s, which is why I sound like Russell Crowe and Sam Neill and Keith Urban, for that matter, rather than Hugh Jackman or those other Australian jokers. We have a sort of a softer, more pleasant accent and so on. But one of my very good students during that time was the first Samoan who went to law school, Tuilomi Neroni Slade. Tuilomi went back to Samoa ultimately and became the Attorney General. And what do you do in a small country after you've been Attorney General? He got appointed as the ambassador, the ambassador actually to the UN, to Washington and to Ottawa for good measure. He called me up when he arrived in New York and he said to me, I have a secretary and a chauffeur and I'm running these operations and I'd appreciate it if you'd do some free work for me from time to time. I don't have a budget, he added. So I said, all right, what kind of free work? The first free work that we did was a case in the International Court of Justice involving nuclear weapons, which I thought was kind of a good start, and we sort of got a reasonably good result in it. And then I said, what next? And he said, we're going to create an International Criminal Court, whereupon I made the first of many quite inaccurate predictions that I had made during this period, because I said, well, that's interesting, and I understand it's on the agenda in New York, but hey, it's not going anywhere, but count me in, it'll be interesting to do that. No, he said, I think this is going to go somewhere, and ultimately we're going to have a diplomatic conference and do this, let's get started. So we started attending meetings in New York at the end of 1995, and sometime in 1997, the Italian delegation turned up and they said, right, we have a venue and a budget for the diplomatic conference to complete this negotiation. We need a date. How about next year, 1998? Say to yourself, oh my God, the Italians are organised, they've got a budget and a venue. As it turned out, the venue was the only ugly building in Rome. It was the building that Mussolini built when he conquered Ethiopia and needed a place to run his new colony out of. Truly ugly, the air conditioning didn't work, and the food was absolutely terrible. It's the only place in Rome where the food is absolutely terrible. But at all events, that was the place where we spent 5 weeks in the summer of 1998 working on this final piece of a negotiation which had been going on. I've always regretted that I've never been quite able to capture what is involved in a diplomatic conference of this kind. We had 160 states participated. We're functioning in 6 languages, all of the languages of the United Nations, although frankly, most of the really nitty-gritty work was done in English and French, to the chagrin of some of the others, and indeed to the chagrin of the French when we did it in English. But we had, say, 160 countries participating. I've never been able to count how many committees, subcommittees, working groups, negotiating groups, and in our case, a coordinating group that were involved in this endeavour. But let me say 40, 50 at least different little groups working on various parts of what became a very complex treaty, which, as I say, was concluded on July the 17th. Well, it sort of was, because we thought we had it all nailed down about 11:30 on July the 17th in what was called the Committee of the Whole, which is a working group in which everybody's there, and then you move from there into the plenary session and sort of rubber stamp everything that's been done. At that point, the Americans called for a vote. And everybody says, oh no, this is what's known as a consensus negotiation, which in many ways is the lowest common denominator. You get what you can get, and you get what you can live with. You give a bit, you take a bit, and hopefully at the end of the day you go, oh no, they call for a vote. Now, there were a lot of people there who didn't know what to do if there was a vote, because their instruction was, go with a consensus, keep your mouth shut, and come home. So anyway, there was a vote, and of the people who actually voted, some had left town by now. Well, I should add something else. At midnight, a little guy in a uniform came around and stole all of the clocks. Time stands still, because it's still the 17th, and the group has authority from the General Assembly of the United Nations only to work until midnight. So it stays midnight. You take the clocks away and everybody pretends. And we got the vote done about, 1:30 or so in the morning. Well, I very carefully did not look at my watch to find out. Anyway, 120 states voted for the treaty, 21 abstained, mostly Arab states, because they couldn't get any instructions from the capital in time. They didn't know what to do, so they hid. And 7 voted no. And it was not a recorded vote, but I put my head around the room and asked people, and I'm pretty sure that the United States, China, India, Iraq, Israel, Vietnam, and Qatar were the ones who voted no. And an interesting and motley crew, but it was the best the United States could line up at that stage to vote against the treaty. And meanwhile, the Samoan delegation, all 2 of us, we were actually quite cheeky because we had insinuated ourselves into the inner sanctums of this negotiation by becoming one of the so-called vice presidents of the conference. A conference like this operates with a sort of an inner steering committee, which in theory makes some decisions about what's happening, and another little group, the Committee of the Whole, which has a bureau, really small group, 4 or 5 states typically, where most of the real decisions are made. We got in the second group anyway, which is 31 vice presidents. For our sins, we got appointed to negotiate the preamble and the final clauses of the treaty. Have we got any lawyers here? Anybody studied international law? Oh, great. No lawyers at all? Good grief. All right. So the preamble of a treaty is a very interesting thing. It's when you try to explain why you're doing this, which isn't a bad idea, except we got to Rome, and nobody had explained. And Samoa thought, go figure out why we're doing this. Figure out something. So, of course, we got people together and talked about that. The other thing we had to negotiate were so-called final clauses. Now, lawyers' eyes glaze over at the thought of final clauses, but the end of a treaty has stuff in it like, how can you amend this treaty? And in this instance, more important, how many states have to become parties to it, ratify it in the normal course of events, for it to become active. Big fight about that part. We had a big fight about the preamble, which we had not expected. You expect something anodyne, bland, everybody sort of here because we want to do justice, we want impunity against the evil ones out there who've been getting away with this stuff and so on. But the representatives of the Holy See turned up. Now, the Holy See is regarded by most countries, not all, as a state, so they participate in this kind of negotiation. And they, I think it's best described, were having a guerrilla war with a set of women's NGOs led by a very determined law professor from CUNY in New York. And among the things they were fighting about was forced pregnancy, because the women's groups are absolutely insistent that forced pregnancy was a war crime and had to be within the jurisdiction of the war crimes provisions, and indeed can be a crime against humanity, another provision in the treaty. The Holy See, however, had a different position on this, because, for example, in East Timor and during the Bosnian conflict, they had taken the position that women who are raped by the enemy should be kept in a way that they can't get an abortion, because after all, there's an abortion kicker in this story. And ultimately, the women's groups insisted that women are entitled to medical care in these circumstances. So the Holy See turns up, and it pops in some language in our preamble about human beings from the moment of conception. You can see where that's going, and it was an ugly battle, and ultimately it got out of the draft of the treaty. The other problem that was happening, and you do a big treaty like this, there are central issues and there are peripheral ones, and some of the peripheral ones can become deal breakers. The other peripheral one that people dumped in our preamble was the question of capital punishment. Now, a capital punishment for the European states, led on this by the Italians, to say nothing of Canada, Australia, and New Zealand, are absolutely adamant there was no way in which there was going to be a capital punishment provision, even for the worst genocidaires in the world. We're not going to execute them. It's a deal breaker. There wasn't going to be no treaty if that was the case. On the other hand, quite a lot of developing countries, including Trinidad and Tobago, which is one of the proponents of the court, was adamantly in favour of capital punishment and wanted it in the treaty. So somebody popped some language in our preamble about capital punishment, which ultimately we get out of there. I mention this because it's like sort of explaining an elephant when there are two of you out of about 1,000 people at a conference trying to understand what's going on. For good measure, the Secretariat, which is running the operation, had run out of people, so we had to type our own documents in the hotel room at night, and then we would send them out on the UN web. They went to Vienna, where they came back the next morning in French and Spanish and Russian and Chinese and Arabic, and then we sort of introduced the documents and explained where we were going. Got a bit of a feel about that. Let me just say something else. And again, my predictive powers on all this are wrong. I was interviewed by a guy from the Christian Science Monitor at 2 o'clock in the morning of the 18th of January, and he said, how long will it take to get 60 ratifications of this? And I said, well, at least 10 years, but maybe not in my lifetime. I was wrong. It took 4 years as it turned up. And in fact, there were about 8 states lining up to be the 60th. So somebody came up with a brilliant solution, which was they could all deposit their instrument, theoretically anyway, simultaneously. So they'd all say, I was the 60th. And this happened, so the treaty came into force, to my utter surprise, in 2002. Now, if you have a treaty like this, big treaty, which sets up an international organisation, which is what we're doing here, you inevitably have some stuff at the edges that you can't negotiate the first time around. You've got to see what you got. So there was a preparatory commission appointed to meet in New York in the months following, which was designed to work out the rules of evidence and procedure, so-called elements of the crimes, dealing in more detail with what the crimes were, working on an agreement with the Dutch, who'd agreed to be the hosts for the court in the Hague and so on. Now, one of the issues that was left over from Rome, and I'll come back to this, was the question of the crime of aggression, crime which was central to the prosecutions done in Nuremberg and Tokyo at the end of the Second World War. But we couldn't get agreement on it, to cut a long story short, on the details in Rome. But there's a provision in the treaty that it was in, but we'd have to work out the details later. And as it turned out, we spent 10 years between 2002 and well, nearly 8 years basically between 2002 and 2010, figuring out the details. Much of it done up at Princeton at the Liechtenstein Institute for Self-Determination up there. But that was left over, as you can see, there's detailed stuff to go. Let me say a bit about the crimes. And this is, my title says human rights. I'm not sure this is a human rights discussion, but it's related to human rights, obviously. The crimes in the treaty are genocide, crimes against humanity, war crimes, and the crime of aggression. Now, it's fair to say there's a lot of debate about what happens if you create an international criminal court of this ilk. What sort of crimes do you regard as the worst kind of things out there and which you should put in front of a body like this?
How is aggression defined?
Well, can I come back to that?
Okay.
I'll come back to it. The big fight that we had in Rome was over the question of terrorism and serious drug offences. Because a lot of the small countries, in particular led by Trinidad and Tobago, which is very keen on this, said, look, we can't prosecute a serious terrorism or a really serious drug case. We don't have the national security to do it. We don't have the manpower. We don't have the apparatus of doing it. We need help. This is why we need a court. On the other hand, large states, United States, Germany, UK, and so on, said, come on. And actually you can see cynicism at play here because we'll dump genocide on a body which will starve for funds and don't take all that seriously. But hey, terrorism is really important. Indeed, unless I'm mistaken, at the time we were negotiating this, the United States Justice Department had more people working on terrorism issues than the whole of the United Nations bureaucracy to work on everything out there. There's a big turf battle goes on here. Big states win this one. Don't get those crimes in there. The understanding is, we'll think about it later on. Genocide, without getting into detail, genocide is defined in the way it's defined in the Genocide Convention. There were efforts to improve on that definition. We can talk some more about that afterwards if interested, but the notion was badly drafted as the Genocide Convention may have been in 1948. We're going to live with it. We can't go there. Secondly, the long definition of crimes against humanity. Crimes against humanity was a big feature of the Nuremberg trials. And to cut to the core of it, what it really meant at Nuremberg is what Germans did to Germans. If Germans do awful things to Poles or Russians or Americans or whatever, that's a war crime. But if you do it internally, and this is unprecedented as a human rights matter, to use criminal law to what people do to their own people. Now, there was a definition of sorts in the Nuremberg Charter. There was a slightly different definition in the statute of the Tribunal for former Yugoslavia, another one in a treaty that was put together to deal with Rwanda. The one that finds its way into the 1998 document is, if you like, the state of the art, which includes in particular gender as a ground for unlawful persecution, includes rape, sexual slavery, and forced prostitution, forced pregnancy, and forced sterilisation in there. And of course there's war crimes. Now, war crimes is a complicated issue, and I don't want to get bogged down in the detail, but there's old series of conventions, the Hague Convention of 1907, the Geneva Convention of 1949, additions to the Geneva Conventions done in 1977, the so-called protocols to them. And what those provisions, particularly 49 and 77, leave somewhat in limbo is the problem of dealing with civil wars, what is usually referred to technically as non-international armed conflict. Now, the International Committee of the Red Cross and many governments, including the United States sometimes and Germany sometimes, have pushed hard for an assimilation of the rules for international armed conflict, the United States invading Canada or Canada invading the United States or whatever, and the rules in non-international armed conflict. We're not there yet. And one of the things that the Rome Statute does, it has two sets of lists, and the lists aren't quite the same. There's broader provisions that deal with international armed conflict, trying to capture something that's really in a state of flux, has been in a state of flux, well, ever since the American Civil War, frankly, and has never been totally resolved on the international scene. The other issue, which was enormously significant at Rome, was the question of forbidden weapons. People like Samoa's, no secret about this, believed that nuclear weapons ought to be a war crime. Pretty simple. You wipe out hundreds of thousands of people in one bit. Everybody agreed that using poison was a war crime. You can fire a poison arrow into somebody, that's a war crime. But you can incinerate a bunch of people with a nuclear weapon. It's not a war crime, according to the friendly owners of the bomb, at least. Indeed, nuclear weapons don't poison you, do they? And they don't asphyxiate you, which is another proposition that we're all agreed upon. They obliterate you, they incinerate you, they vaporize you, but that's not the same, according to the nuclear powers. Turned out that one was a deal breaker. The permanent 5 members of the Security Council and the members of NATO would just simply never agree to a treaty that had done it. So we lost that story. On the other hand, we got poison and asphyxiating weapons and expanding bullets in there, but not biological weapons and not nuclear ones. One of the big issues, aside from what sort of crimes, is jurisdiction over whom. And the conclusion that was arrived at was not the conclusion that, for example, Germany and Samoa had argued for. We thought that genocide, crimes against humanity and so on, are such significant crimes that however many of us become party to the treaty, set up a court, we could try anybody, whether they're parties to the treaty or not. And we've ultimately got 123 parties to the treaty. It wasn't a proposition that others of the large powers in particular agreed to. Their position ultimately was that the state on the territory of which it occurs, or the state whose nationals do it, had to be a party to the treaty in order for there to be a jurisdiction. And we ended up with that, I'm afraid. Just a couple of other points. One is the question of victims. Back in the mid-1980s, you may remember, there was a lot of discussion about victims' rights coming from all various parts of the spectrum. And the United Nations had a very important declaration in 1985 about the rights of victims. And a number of provisions from that declaration found its way into the Rome Statute, so that victims are entitled to participate in various ways in the proceedings. They're entitled to apply for reparations, and there's also a victims' trust fund set up to do something about the victims that are out there, on the understanding, which has for the most part proved accurate, that the kind of defendants you ultimately get in front of the court don't have any money. If they had it, they've salted it away somewhere and you can't find it, or the state wants it back from whom they stole it, and you're not going to get it in the system. So, in fact, the victim stuff is really quite complicated. Let me say a word about aggression, which was, in many ways, the difficult issue, and which was central to Justice Jackson's prosecution theory in the Nuremberg trials. The central crime, as he saw it, was that the German Nazi state and its collaborators, including ultimately Japan and so on, were guilty of the great crime, the crime of crimes, in waging an aggressive war. The Russians agreed with the same notion. The French and the British were not so enthusiastic about prosecuting for that, but they went along with it. And of course, Justice Jackson at Nuremberg made the famous statement that what we try the Germans for this year is something we have to hold ourselves accountable for. Put a poisoned chalice to their lips, we're ultimately putting a poisoned chalice to our own. Now, of course, when push came to shove in the ICC negotiations, the team that gave us Nuremberg was less than enthused about the possibility of their own poisoned chalice and made it very difficult to conclude this part of the negotiation. But ultimately, we got an understanding in Princeton subsequently, which was adopted at another conference in Uganda in 2010. And essentially what the definition of aggression does is do two things. It describes what a state does. And this is an absolutely crucial point about the whole enterprise, actually. If you think about a war crime, and typically, but not always, a crime against humanity, these are crimes that by and large are done in the name of the state. The state is doing awful things to people, and who does the awful things on behalf of the state? Namely, its agents, its people. It's military and non-military leadership, and maybe even the foot soldiers and so on. And the big thing from a human rights point of view, the paradigm shift, if you like, that happens at Nuremberg is to take the notion of state responsibility. State A must not invade State B, and say, all right, in addition to that, there are some people who are responsible for that. And in the case of aggression, the leadership. So what happens with the definition of aggression, there are a list of things, invasions, bombardments, annexations and so on, that are illegal, but then you link them to the particular people who do it, namely those who are in a position to control the military or leadership or political leadership of a country. Pretty good definition, in my view, works out the details quite well. I've talked for longer than you wanted me to talk.
Oh, no,
You have more time.
I can go a little bit longer.
Yes.
I just wanted to sort of comment, I suppose. I'd much rather take some questions.
You have at least 10 minutes, 10 to 15 minutes.
That's right. About where we are now. Because I think in some ways the output of the court has been a little disappointing. We've got 3 or 4 convictions. There are another half dozen or so cases in the works. There are 15 defendants out there whom it hasn't been possible to arrest. I mean, the court doesn't have a police force that parachutes in and says, gotcha. They got to rely on states to turn in the people. They're slowly getting the defendants that they want. As you would expect, the crimes that have been prosecuted cover the whole spectrum. We've only just activated aggression, so we haven't had any of them. But the first case is one involving child soldiers, very important issue in modern warfare, particularly warfare in non-international armed conflict. The second one, the whole panoply of crimes, rapes and murders and thieving and all of that stuff. You may have noticed the Timbuktu case that